Hi, I'm New Mexico attorney Nadia Cabrera-Mazio, and I actually enjoy reviewing contracts because I'm not just reading the contract. That would be incredibly boring. I'm investigating. I'm looking at the big picture and at all of its little parts to make sure that not only is my client protected, but that the contract actually reflects what that client is trying to achieve with the other person. I look for a lot of things when doing contract review, but today we're going to talk about the top 5 things I look for as a contracts attorney. Number 1, contract elements. Without the 6 contract elements being present in the document, it's not going to be a legally enforceable document. So if I can glaringly tell that a element of contract law is missing, then I won't even offer to review that contract because it would be a waste of the client's money. It clearly needs more drafting work. The 6 contract elements are offer, acceptance, capacity, legality, consideration, and mutual assent. And we could do a video on each one of those, but basically those have to be present, and I'm always looking for them when I'm reviewing contracts. Number 2, clarity. Does the actual contract make sense? Is it clear who exactly has to do what and when, and if appropriate, how they have to do it? I also like to see the answer to the question why the parties are entering into the agreement, and that's usually found at the very beginning in the recitals section of the contract, which itself is not usually legally binding. I always like to include a background section in my contracts because it gives context to the transaction and to the relationship of the parties. If there is a dispute later on, it'll make it that much easier for the judge to be able to interpret the contract and find a solution. Number 3, missing or incomplete sections. A good example of this that I often find is either missing or incomplete is the termination section. The contract should be clear on under what circumstances can the relationship or the transaction end early and what happens when those circumstances come about. Wishful thinking is great, and you should be working under the assumption that things are going to work out swimmingly. But unexpected things happen all the time, situations change, and sometimes things fall through. You want to make sure that the document contemplates those circumstances and is clear so that when you're dealing with that stressful situation or a conflict where the relationship between the parties is breaking down, you want to make sure that you don't have to worry about how to dissolve that contract. It's already taken care of. Number 4. One-sided clauses. One of the things that I love about contract law is that it is based on the principles of honesty and fairness. Fairness means that there's a give and take and that one party's not getting everything at the expense of the other party. One-sided provisions in a contract can be totally fine and appropriate under certain circumstances, but oftentimes they're a red flag that something might be a little unfair. One area that I often see one-sided indemnification clauses, which is when one party protects another party from liability under certain circumstances. For example, if you get in trouble, if you get sued for something that I did as part of our contract that you had no control over, then I'm going to indemnify you for that circumstance. This is one thing that I think almost always should be a two-way street. If one party is going to be indemnified for a circumstance that they have no control over because the other party did something under the contract, then the other party should get that same benefit. And finally, number 5, the big picture. Is the contract itself a realistic representation of what the parties are trying to achieve? So those are just some of the many things I look for as a contracts lawyer when I'm reviewing a contract.